Good evening. Welcome to this, welcome to tonight's planning commission meeting regarding, well, many things actually. We'll outline them here in a second. I'll call the meeting to order. Mr. Kobayatsman. No problem. Been there, done that. May I have an approval of our agenda for this evening?
Motion to approve.
Motion to approve, rather, yes. Do I have a second?
Second.
Would anyone like to discuss the agenda? Okay, Tessa, will you call the roll?
Commissioner Moritz,
Yes.
Commissioner Sinclair,
Yes.
Commissioner Ostrander,
Yes.
Commissioner Matusek,
Yes.
Commissioner Bates.
Yes.
Commissioner Farrow. And Chair Newton.
Yes. Move on to consideration of the minutes from our January 18 Planning Commission meeting. Did anyone have any amendments to those minutes? No? All right. How about a motion to approve?
Motion to approve.
Thanks, Mike. Appreciate you, Evan. Thank you. Second?
Your wingman.
Don't be shy.
I'll second.
Thank you. Any discussion? Okay, Tessa, will you call the roll, please?
Commissioner Sinclair,
Yes.
Commissioner Ostrander,
Yes.
Commissioner Matusek,
Yes.
Commissioner Bates.
Yes.
Commissioner Moritz,
Yes.
Chair Newton.
Yes. All right, Bill, I'm off script here a little bit, so check me. We're going to start with a public comment section. That is an opportunity for people to bring before the Planning Commission items they believe are within our purview and should be considered. Let's not have comments related to the legislative item we're going to consider tonight in that section. So we'll have two public comment sections, kind of an open-ended public forum, public comment section, and then we'll have a specific opportunity for people to comment within the construct of the legislative hearing we're having tonight. So if you'd like to make a public comment regarding something you believe within the Planning Commission's purview, please raise your hand either virtually or here in person tonight. I'll recognize you, come forward, state your name and your mailing address, and keep your testimony probably 3 minutes. So that's pretty consistently doing that. Yeah. Okay. Is there anyone who'd like to make a public comment at this time? No, anyone? Okay, well, we'll move on to our main item tonight. It is a legislative hearing regarding continuation of ZO 23-02, the City of Cannon Beach request zoning ordinance text amendments. ZO 2302, City of Cannon Beach request for zoning ordinance text amendments to Chapter 17.43 Wetland Overlay Zone. The zoning text amendment request will be reviewed against the criteria of the Municipal Code Section 17.86.070A. Amendments criteria and the statewide planning goals. The initial evidentiary hearing for this application took place October 26, 2023. Does anyone object to the jurisdiction of the Planning Commission to consider this matter at this time? Does any Planning Commission member believe he or she has a conflict of interest or personal bias? Okay, we need any ex parte contacts? I guess that would apply.
Actually, ex parte contacts don't apply to legislative.
Okay, strike the whole section. Glad you got my wing. Okay, may we have the staff?
I don't have, sorry.
I'm gonna come get it.
Right. They'll be brief and, point here. So we had, this is our second evidentiary hearing on the wetlands ordinance. I believe the initial one was in October.
26, yes.
So we had the initial hearing. There were some things and comments that people had. So there were work sessions with the Plan Commission, the Council and Design Review Board. There were also some tweaking of just staff working with some members to get the ordinance to a point in time to bring it back based on all of those initial meetings and information. So basically, we're back for the second evidentiary hearing on this matter. The amended ordinance is presented before you this evening. And it with findings demonstrating compliance with the applicable economic, social, environmental, energy consequences, which is what we've referred to as that easy report that the Department of Land Conservation and Development is requiring the city to provide when making such an amendment to the wetland sections of the zoning ordinance. During this hearing and possible future hearings on the matter, Plan Commission will hear evidence regarding the proposal, conduct deliberations, and make recommendations to the council regarding the proposed code the wetlands ordinance. This is an opportunity for everyone who's had interest in the wetlands ordinance to have their voices heard. The council will then hold a public hearing where it will likewise hear evidence and conduct deliberations before making a decision on the proposed revisions. And the date of that initial evidentiary hearing before the council is yet to be determined. And that would take place once the Plan Commission would make a favorable recommendation to move forward with the proposed wetlands ordinance as is. So that's the staff report, and Marcy from Herbs Work is here and she's ready to have, as well as Keith Leiden, who's works with Herbs Work and us, our consultants. So they're here as well to discuss the proposal this evening.
Is there any additional correspondence besides what we were given? Have been provided? Any other additional letters come in last minute? Sometimes we get those.
Yes.
We're good.
All right, so we'll call for public testimony now. The pertinent criteria to be considered in the staff reports and listed on the criteria sheets for the city's meeting page and of the city's website. Testimony or evidence must be directed toward those criteria in the comprehensive plan or within this planned revision, which the person testifying believes apply to the decision or to our consideration. This next section does not apply. Persons who testify shall first receive recognition from the chair, state their full name, mailing address, and if appearing in a representative capacity, identify whom they represent. Would anyone like, in the audience here tonight, would anyone like to come forward to make their public testimony? Commissioner Kerr, please come forward.
My name is Lisa Kerr, Post Office Box 94. I'm coming in no representative, citizen of Cannon Beach. Also, I did work on a working group who initially formulated this ordinance and then handed it off to professionals, Marcy and her team. So, and I just want to say one thing very quickly. The expansion of the buffer from 5 feet to 50 feet sounds so dramatic when you look at it on its face. But actually, the opposite is true. It's on the low end of what is considered best available science for wetland protections. The working group looked at ordinances from many, many other jurisdictions. This is conservative, 50 feet. So even though it sounds like such a change, it's because our previous one was literally worthless.
Thank you. I'd like to come forward. Who's in the audience tonight? Please come forward.
I'm Susie Logan. I'm PO Box 484. Try to speak as quick as I can because I have to say. And what I do want to say is all wetland related. I hope it feels appropriately related. I want to begin by saying that the process of notification for this public hearing has been troubling to me. The initial notification that I saw on February 8th was contained within the agenda and minutes section of the city website. And this notification stated a posted dated date of January 31st, and yet no one I knew had received this notification via email or any other public posting on the city website. Even more alarming was the statement within that notification, which read, "Failure to raise an issue at the public hearing in person or by letter, or failure to provide statements or evidence sufficient to afford the decision maker an opportunity to respond to the issue precludes appeal to the Land Use Board of Appeals based on that issue." And I sent an email to Mr. St. Clair and asked if it was legal to have a notification posted nowhere other than within the agenda for the same date. I never had a response, but the next day, February 9th, a completely rewritten notification appeared on the site. And it was phrased differently and stated, "The Planning Commission will not be addressing property-specific questions during this hearing." So within 10 days of time, the city went from a hidden notification informing residents to state your complaints now or never to "we will not address property-specific concerns, so keep your concerns to yourself." Does this seem ethical? Does it even seem like a legal public hearing with shifting restrictions being commanded? I have to say this confusion seems to be status quo for this entire wetland amendment process. And here are some of my other wetland concerns. First, the city has explained that the initial effort of this amendment process was undertaken by a group of local citizens. Has anyone questioned the intention of this local group? This is an important consideration for such an important topic as wetland protections. I hope we can agree on that. At least one of these local citizens is currently involved in a legal dispute directly related to wetland and overlay issues, and so is the city. I know this because I'm involved in that dispute. Why would the city allow a group of non-wetland specialists to lead a wetland amendment process? And why has UrbWorks, a team of urban designers, been hired to assist rather than wetland specialists? I've wondered this before and I wonder again tonight. My second concern is regarding the city GIS maps. If the goal is actually wetland protection enhancements, why has the city created utterly false GIS map diagrams for the north end of Cannon Beach, from which these revisions are being drafted? The city has made it clear that the new map system currently reflects information gathered from a 1993 Cannon Beach wetland study. So the new system is basically functioning at a 30-year-old model already. The city also states that they're updating the map as new information is provided. And yet a Windsor study, which was commissioned by the city and completed in August of just last year, was provided new information, which the city seems to have determined not to include in their wetland revision process. Why is this? Last year, the Windsor Engineer Group was commissioned by the city to study reoccurring flood issues, including wetland and wetland overlay areas in the north end of Cannon Beach. In August of last year, the Windsor assessment completed the City of Cannon Beach 7th and Laurel intersection stormwater and flooding assessment. I've read that study and the results were important. I believe surprising to city staff members, especially our city manager, who had concluded prior to the study on his own accord that the flooding on 7th and Laurel Street was, number one, not the city's problem, and number two, due to king tides with extreme rain events. In both cases, the Windsor study confirmed that the city manager's statements were false. I want to share more about this 2023 study because the findings relate directly to wetland matters. The area with the Windsor study assessed is concluded in the City Wetland Ordinance Revision EC Map number 1. I've compared the city's EC Map number 1 descriptions with the Windsor study descriptions of the same area, and Planning Commission and residents, the findings do not align. In fact, currently on the city site, there exists a newly named stream, number 18, which falsely erupts out of the middle of my backyard from nowhere. For the sake of reality, I want to say tonight that there is no stream in my backyard, nor was there listed one in my title search records when I purchased my property in 2018. I have known of a culvert which begins on my adjacent neighbor's property to the north and a stormwater source which begins on the hillside above that property to the north. As recently as August of 2023, this stormwater system was described by Windsor engineers as an unnamed stream. In addition, I've confirmed that several history by location documents also refer to this as an unnamed stream. The new city reference came from the 1993 wetland study, but in 2023, professionals in the field were still referencing that stream corridor as unnamed, and there must be a reason. In a public works meeting just a month ago, Ms. Labonte described the Windsor study and the 7th and Laurel issue as complicated. And she acknowledged that the stormwater is a receiving point for many sources of water, including Ecola State Park. And yet the Windsor study confirmed that ODOT and the state park both had no information regarding the origin of this water. Nothing is factual about this stormwater system identified in the city map diagram for my property or the surrounding area. Does that seem extremely odd? This confusion is supposed to be the considerable way to update the process. It seems rather to be perpetuating inaccurate, false information, which now is being drafted into amendments. A couple of months ago, I contacted Mr. Sinclair directly to inform him of these inaccuracies, and to this day, those false depictions remain on the site. Is this reasonable? Is this even legal? How many other inaccuracies exist on the GSI site right now? How many of these amendment ordinances will be created as a reflection of the false city mapping? And ultimately, will those changes protect or hurt the wetland areas? Property owners, beware. And please read the disclaimer on the city site, which states that the city is not to be held responsible for any inaccuracy of those maps. The conclusions of the Windsor study in 2023 confirmed that none of what was suggested by the city prior to their study was true. It suggests the results of the analysis were due to a cause of flooding and a consequence of large rainfall events and a lack of ability for the unnamed tributary to convey events larger than the 10-year design storm. I'm almost done. The Windsor study also confirms that this stormwater system is in need of drastic updates, which have not occurred for at least 50 years or longer. They explain that the stormwater system, or stream number 18, as some would call it, has capacity issues when storms greater than the 10-year design storm occur. Specifically, and I quote, point number 1, the downstream creek has fallen trees and other debris that prevent optimized drainage of the 7th and Laurel intersection. Point number 2, the topography of the area may not be conducive to avoiding flooding in storms that are greater than the 10-year design storm event. Point number 3, private stormwater system improvements are not fully documented. It is unknown what design criteria were used in sizing any private pipelines, culverts, inlets, and screens, and whether the sizing and configuration is appropriate to avoid flooding. And point number 4, it is possible that some of the public or private pipelines are partially plugged. This, city representatives, this is an example of details to assess for wetland revisions and updates to wetland codes. Has the city chosen to implement any of the Windsor study recommendations? No. They have not. Why is the city ignoring recommendations from specialists in the field? When recently asked by Public Works Committee members that the city was doing in response to the findings of the Windsor study, Ms. Labonte's response was, the city took steps and hired a third party to evaluate the area. That was the Windsor study. And quote, we could build several culverts and upsize pipes, but because it was full, there was nowhere to put the water. This is the fact of the situation. I would say no, Ms. Labonte, that is not the fact of the situation. The fact is that the Windsor study confirmed that the flooding is due to decades worth of mismanagement of the stormwater system, which flows through the north end of Cannon Beach above North Laurel Street. The reason there is nowhere to put the water is a byproduct of this mismanagement. So for the sake of the wetlands, this needs to be addressed. And for the sake of what's happening tonight, Planning Commission members, the city actually could bring riparian codes to current standards. I would suggest that that is exactly what the ecological and legal responsibility of the city is to do at this time. And the attempt to fast track these code changes are a direct response from the city not feeling up to that task. And again, reinventing codes that remove their legal responsibility from these matters. My final concern for this evening is this. The city has proudly announced this amendment is being fast-tracked and is a component of the larger zoning code revision process. My question tonight for all local residents of Cannon Beach and this Planning Commission is this. Why would any legitimate wetland proponent believe that fast-tracking these amendments is a wise idea? Why would any legitimate wetland proponent not insist that this process be thorough and scientific and complete implementation of recommendations from engineers who specialize in the field, rather than use this proudly fast-tracked audit code process to cover up existing legal conundrums that the city is challenged to address? If anyone is curious to understand anything more than that I have shared tonight, I have thorough documentation and I'm happy to provide it. Thank you for your time. I'm sorry that was so long.
Thank you. Is there anyone else in the audience who'd like to come forward with public comment? Please come forward.
Carmen Swigert. I live in Cannon Beach for about over 50 years. I live in the north side of Cannon Beach. I have a business and I've been a long-time resident. And all my family has lived here in Cannon Beach. And I am appalled at what I have just heard from the lady previous to me. I do not believe that the city should take any main decisions at this time that will affect any of the wetlands, and it will affect residents, and it will affect property owners. And your decisions evidently have not been made according to some of the rules that elective official should follow. Okay. What I heard from what the lady says is she is implementing what she has read, and she is providing you with notification that you need to do better studies and follow what the recommendation of the professionals are. Not because you are sitting in the position of representing the city of Cannon Beach, that does not give you the freedom to just apply laws and change and amend policies or the planning, the city planning and all of that when it is going to affect a lot of people. And the lady has expressed very clearly what her concerns are, and some of those concerns, I feel that they also come. I own the property right by at Sea Ranch, and we have gone through this previous to this change, when all those laws were presented and we have been following. And I don't understand how come we're going back again with the very same thing. You know, it does affect my business. Yes, affects my business. It does affect a business that is paying taxes to the city, and we collect transient room taxes for the city benefits and probably use them for some of these issues. It just kind of bothers me the way that the city is operating. I've never seen this happen before. Okay, so I just would like for you to review and don't be so rushed into passing and changing the rules that we've been going by. If you do not want to follow the recommendation of the professionals, I don't think that you should move in going ahead and make change that will affect the citizens of Cannon Beach that are next to the creek, or even for everyone else. I just don't understand how could things like that be happening in this city. Really, the first time I heard this, I'm just amazed. I'm sorry. Okay, that is my opinion. Thank you.
Would anyone else in the audience like to come forward with their public comment? Please.
Hi, my name is Scott Robertson, and I am representing some property owners here. My post office box is 836. And so I have kind of an interesting situation where I'm in a kind of a pre-construction design phase with some clients who are looking to hopefully obtain building permits and move forward with the project that you guys might be familiar with. It's been there for a long time now, and it's right next to a wetland. It's at 116 6th Street, right off Ecola Park Road, the north end of town. And so the thing has been in the works for 15 years or so, all told. And so what we have, they got to a certain point where they did the wetland delineation report, and that went up to the state and came back, and all the engineering was done. The pilings were put down close to 50 feet. I think there's 16 of them. There's a steel foundation that's sitting on top of those pilings right now, and that's just been sitting there for quite a while. I think some of the utilities have been brought up onto that site as well. And so what we're doing right now, okay, I should say that that parcel then was purchased by my clients March of 23. And now we're looking at what we might need to do to breathe life into this project and hopefully build on this foundation that's just been sitting there. And so I have met with Mr. St. Clair and Mr. Sokolowski. February 7th, we had a meeting to look at the parcel. And we got that up and looked at that, and we did some document review just to kind of see where we're at with this. Obviously, all of the stuff that has been done has expired. And so now we want to figure out, that was my purpose of meeting with them, was where can we go from here? So they asked me to bring in a new wetlands expert, and we're going to submit for another delineation report. I did that. They also asked that we bring an engineer in to look at the structure. I did that. So we're just, this is kind of where we're at with that right now. I met with the wetlands experts and we looked at that, and they did say that, yes, obviously we're right next to the wetland there. Just it's a kind of a small area, and there was some remediation stuff done with that in the past, and I have records of all of this. And so it's my understanding that you guys are considering making some changes with the existing rules and regulations with regard to these wetlands. And it is my hope that since we have in the past, I know it's in the past, we did get the permission to do this here. And unfortunately, those original owners, for whatever reason, weren't able to go all the way through and realize the vision. And we would love to be able to take whichever steps are necessary right now to just have a chance to realize that original vision and build at that site. And so just wanted to come in here tonight and get on record as you said that.
Thank you.
Thank you.
Is there anyone else in the audience that would like to come forward with public testimony? Please.
I'm Jan Siebert Orman, P.O. Box 778. I just want to say that I think the intention people have done, the group that came together to do this wetlands change in our town, have only the highest and best intentions. I'm just very grateful to them for all the time and energy they put into this. If there's tweaks or anything that need to be made, I would totally look at those tweaks, but I just want people to understand, from my point of view as a longtime citizen here, that I really believe that the people who put this together and are trying to help our city protect our wetlands have just the best intentions. Thank you very much.
Would anyone else like to come forward at this time? Okay, anybody online have their hand up? Robert?
We do.
Okay. You got a name or something?
C. Mirth Walker.
C. Mirth Walker.
Okay, yes, please go ahead.
Do you want me to show my video or not?
That's entirely up to you. I would like your mailing address.
Okay, I'll just go with this. My name is Mirth Walker. My mailing address is 4910 Southwest Richardson Drive, Portland, Oregon 97239. I have family property in the north end of Cannon Beach, not in the lower end, but in the higher end off Beach Street. And I would like to clarify in my cover letter that to my comments that I submitted February 19th, and as mentioned earlier, that Keith Lydon is a subcontractor to Herbsworks rather than a contract city planner. I won't reiterate my comments, just highlight that I reviewed the draft code in light of my 34 years of experience as a consulting wetland scientist, working with the wetland regulatory codes of many local jurisdictions, and that our property has an off-site wetland to the north with a buffer that partially extends on site less than 50 feet. So I looked at how the code amendments would play out in that scenario and offered suggestions on how to determine how much buffer is on site if off-site access is not granted. I added definitions and clarifications, hopefully. I fully support increasing the wetland buffer from 5 feet to 50 feet I believe that is the minimum necessary to protect the integrity of our wetlands. And I just want to say that there's several issues that I've heard tonight, and the primary issue that we're dealing with is code amendments to how we regulate wetlands. And I heard issues about how do you do map amendments if you don't think the map is correct, and that's for another discussion. And also stormwater management is separate from code amendments. So I just like to remind people that what we're dealing with is draft amendments to the code of how we regulate wetlands. And I'm happy to answer questions or participate in any sort of work session or consultation as a professional wetland scientist. Thank you.
Appreciate your very extensive comments to us. We'll maybe have some questions for you later. Thank you. Is there anyone else online?
No.
Okay, going once, twice. Anyone here in the audience or online? Last chance? Okay, then we'll close the public comment section and move to deliberation. Would like to lead off.
I would like to thank the last public commenter on Zoom for pointing out the difference between the stormwater issue and the wetland buffer issue. I was going to attempt to do that, but I'm very glad that a wetland scientist did that for me. So thank you.
Well, I guess I can start with some questions just to get the ball rolling. Keith, did you have a chance to go through everything that was sent to you by Mirth Walker and take a look at whether you thought those changes, or Marcy, maybe I have to direct that to you?
And I will direct it to Keith. We've been in correspondence about it.
You want to lead on it, or you?
No, I don't need to. Thank you.
Okay, that's past due time. I'll take it as Keith, you're up.
Yes, I reviewed Mirth's proposed amendments, and I think similar to the amendment suggestions we got from the DLCD representative that I believe is in your packet, Amanda Putin. I think both have given us a number of very helpful suggestions. Now, the amendments that I felt were, and that was most of them, workable, are from DLCD are incorporated in the draft that's before you. So you'll notice there was some reorganization from the previous draft that you've seen and so on. And as far as Mirth Walker's comments, I have not made it, you don't see any changes reflected in the draft from Mirth, but I think again, she had some helpful suggestions to clarify terminology and, what process are we talking about and that sort of thing. So I think there are a lot of things that she has to offer that we should incorporate into the draft. You may notice too that both the comments from DLCD and from Mirth were not related to the draft you're seeing tonight. It was a previous draft. So as I said, most of the amendments recommended from DLCD are reflected in your draft, but Mirth's comments are not.
Keith? Those comments from DLCD, they are in our draft somewhere? I hadn't seen them.
The comments themselves, I don't remember what all went in the packet, but the changes that were recommended by DLCD are reflected in the draft that's before you.
Okay, is it reflected in your table 2 in any way? I was trying to figure out that terminology you used. And there provides additional clarity and reader convenience. I didn't know if that was your comment or something that came from DLCD. The second row down on definitions. I see your comment that provides additional clarity and reader convenience. And I was wondering if those are the type of comments we were getting from DLCD, or was it something different?
Well, one of the fundamental comments is that we needed to show a clear and objective path for approving or at least reviewing residential development.
Mhm.
And the other thing that we realized was that we weren't being really clear about which things were going to be subject to this overall 1,400 square foot limitation, 1,000 square feet for building, another 400 square feet for other site improvements like parking or walkways and so forth. And what types of development really isn't subject to that 1,400 square foot limit that would be outside of the lot of record requirements. So some of those things would include streets, pathways, utilities, those sorts of things that would not be, you would not be looking at the square footage. You would be looking at the impacts and how you best avoid those impacts or mitigate for those. So that was a change in how this, the approach is done. My understanding, and Mickey can correct me if I'm wrong, but my understanding was that that was really the intent and how the ordinance works now, that things like utilities and so forth weren't really subject to the lot of record requirements. It was really about residential development. We put residential and commercial development in the same group so that any commercial development is also subject to the same lot coverage restrictions that we have for residential.
And to clarify again, Keith knows this, but I want to make sure that anyone listening understands. When we talk about size limitation, we are talking about in the event that there is not enough upland on a lot to build the house that you really want to build, as big as you want to build it, given our FAR limitations, and you need to encroach onto the buffer or the wetland, then there's going to be a limitation in size because of that encroachment. But you still have the full use of the rest of the lot. So I think we just have to be really careful with our terminology that size limitation relates to when it's necessary, absolutely necessary to encroach into the buffer or the wetland. And if, while we're talking about encroachment, Keith, do you mind if we revisit one more time buffer averaging?
Oh, I
We've been through
guess.
this many, many times. But it looks like several people now have suggested we go back to the term averaging. We may want to consider that. Just say, okay, we're going to go with the standard term. As I looked at the code again, I was thinking there is a section in 1743. Let me find the initial. 060E, the site alternatives analysis.
Right. Mm-hmm.
And that basically sort of walks through the same thing that we repeat in 1743-070C. But I wonder whether it makes sense in the site alternatives analysis to simply explain that they need to address each of the alternatives in turn in 070, because when I read the terminology in 060 versus 070, it's not exactly the same. And I think it could be confusing for an applicant to question, am I using the site alternatives analysis or do I need to go to 070? So I think we should describe the process one time, not two times.
Yeah, the idea with the submittal requirements in 060 was to really make it clear to the applicant your analysis needs to march through the process. So then when you get to 070 to address the criteria, you've essentially have that information there to do it.
Yeah, it's not.
I'm doing that partly because, at least in my experience, applicants a lot of times have a hard time giving you a good narrative. And so if we just give very general instructions about what to do, then you get usually a fairly general narrative that sometimes isn't very valuable. So that was my intent, to really try and make it clear to the applicant, just march through this analysis, and then you will be in good shape to address the criteria or show the justification. So we could make this simpler. Certainly, if I've got some issues with conflicting terminology or confusing terminology, we'll get that fixed.
to me, as I read the two, they don't align exactly. So either they need to be very, very carefully aligned, or there needs to be one reference only so that we don't end up with potential conflict.
Yep.
And the one change I would make in both of those sections, when we refer to buffer averaging, I think it needs to be really clear that buffer averaging is available only if there is enough area to average the buffer on the lot, so that there is enough upland to increase the buffer to make up for any reduction somewhere else. This says where upland available, and that's not as clear as upland will be adjusted so that the total area stays the same on the lot. So I think we just want to be really, really clear about what our intent is there.
If there is a lot that doesn't have enough upland to satisfy the
averaging doesn't
average, they
work.
just do the best they can, and then that's, we call it
No,
good.
because in that case, they would need to move on to the buffer reduction plus mitigation. So buffer averaging is self-mitigation. If the project can't self-mitigate by averaging out available buffer area, then they need to move on to the next step, which is to apply for a buffer reduction plus mitigation with a mitigation plan.
Oh, okay, I didn't have that understanding, so we'd have to
Yeah,
add
so
that.
that's, I think
Okay.
if that's our communication, I apologize for that. But the key with buffer averaging is that a mitigation plan is not required specifically because the mitigation has occurred through the averaging process itself.
Right. Okay. So the one
Guys,
we're
I would
talking
love to
about
say-
is the one with the 25% limit on the encroachment.
Yes, so
And
that
then
is
they have
buffer
to-
averaging.
And if they don't have enough upland area to compensate 1-to-1, then they
Then
go
they need to move on to step 3.
and they have to provide some mitigation like in step 2. Okay, sure.
But otherwise, I think you've really done a beautiful job with this, and I'm thrilled with the result.
Good, thank you.
I have just a question though, Keith. Table 1743-1, is that a complete table or is there something to be added to that? On page 5 of the draft.
One thing I noticed, and I'm not sure how this happened, but for the review process, Planning Commission got left out. I think it was something to do with adding and subtracting rows on the other side, and I was surprised to see that when I opened this up tonight. It's very similar to before, so that the type 2 administrative review that you have now would apply only to the vegetation management to the extent necessary. And then the others are all Planning Commission review. Some of those are wetland lot of record with the 1,400 square foot limit on what you can do. And then some of the other things like streets, sidewalks, utilities, land divisions, those other things that aren't really subject to the 1,400 square foot rule, but we have other requirements. Many of those are the same that you've had before, it's just in a reorganized form.
On that top one, below the line, wetland lot of record, what does that mean structure or does that mean something else there?
That's referring to the types of development that you are allowed to have regardless on a wetland lot of record. So that's defined as 1,000 square feet maximum for a building and another 400 square feet for things like driveways, parking, walkways, etc. So it works in a very similar way to the way you have it now. It's just that right now, I think it's a 2,500 square foot limit. So we're reducing the limit by 1,100 square feet.
Yeah, it's just that doesn't just jump out at me when I see it, that's what you mean.
Well, then you go down to 070 where it talks about the wetland lot of record and what the requirements are, and that's where all that is. This is just talking about, this table is just intended to say, here's who reviews these things.
Yeah.
That's all it's supposed to say. And what I did do is I changed the terminology in the table to coincide better with the different requirements that you find then in 070, so that the wording is the same.
So just take a couple of examples then, if you don't mind, Keith. So let's
Sure.
assume that everything can be built on the upland.
Right.
Does that fall under type 3 planning commission review?
If everything can be built on the upland, they just get a building permit, I think, unless they need something else. If they're outside the buffer area and everything else, then this doesn't apply. This only applies if they want to develop something either in the buffer or the wetland.
Okay.
So obviously our preferred course is for them to find a way to just stay out of it altogether.
So I'm just wondering if it would be clear to say, because it's 070, let's see, you said wetland lot of record, no 70. Everything else there is called out. Why don't we just call it structures?
Something in there.
One of the things we're trying to do here is follow DLCD's requirement that we have a clear and objective path for residential development. And that clear and objective path, we were told, could be a no answer, but it's still a clear and objective path where you don't have subjective criteria, which is why we have the square footage numbers and so forth. So it's pretty clear. This is what you can do. If you encroach this much, this happens. If you encroach this much, this happens. And if you're into the wetland also, then this happens. And so it provides a pretty clear, really not a subjective path. The other ones can be more subjective with some of the criteria, but that's okay. And like I said, a lot of your standards for the other types of developments like utilities, sidewalks, stormwater management, and so on, stay very close to what you have now. They're just reorganized.
I get what you've done now. I think, so what you're saying is when it says wetland lot of record, you're saying that's a case where the applicant comes in and they can't do anything but use buffer or protected wetland. I think that's what you're trying to say, right? And then,
Correct.
okay.
Correct.
Thank you.
And then even before we get to that, if it looks like they are have a problem because they have to also meet their setback requirements and lot dimension requirements, that the first step that we'll try according to these rules is consider an adjustment to those two types of requirements of reducing them by 50% and see if that's enough to keep them out of the buffer area. And if that's the case, then great, we give them the adjustment and then they're done. But then with the adjustment, it still would help minimize how much the encroachment would be. So the adjustment would be the first thing if they can't fit the 1,400 square feet in an upland location.
And how would the adjustment be reviewed then? I guess it would just come in with the original application, right? The adjustment
Correct.
wouldn't be, okay, thank you.
And that would be reviewed by the planning commission.
Thank you.
I had a question. I'm wondering, when you're taking a look at that table 1743-1, was it the question because in all that section, there's that empty box?
Yeah, that was it. I just didn't know.
I don't know if you noticed that, Keith, but when you take a look on page 5 in the table 17-43-1, the box is empty. And
I know. Something happened when I was adding and subtracting lines on the left-hand side, and the planning commission went away, and I don't know. I
So
think
that would be
somehow
it.
planning
I got it.
commission was linked to one of the other rows, and I took it out, and I didn't see the planning commission disappeared along with it.
and that's supposed, and that would be in there.
Yes, so
Yeah.
planning commission would be reviewing all those others.
All right.
I know it can be really slow and painful, Keith, but I can take it in. Yeah. Kidding.
So I had a question. Go ahead.
Nothing important. Go ahead.
I actually just thought of a question that I'm hoping Bill could weigh in on. Bill, is it a concern that we define reasonable use in the code here? I mean, because reasonable use also has its legal meaning. is it okay that we're using that term and making a definition for it?
And so when you're talking about defining reasonable use is that where, and I'm trying to remember where.
Okay,
that
yeah,
is.
so to recap,
Yeah,
we define reasonable use as being able to build a building footprint of 1,000 square feet on a lot. So you could build more than that if you've got the upland for it, but we're saying if you're crunched into using buffer or wetland, that's the maximum coverage, and we're calling that reasonable use. And I wonder if it's problematic to use a legal term for this purpose.
I don't think it's problematic, and I think the definition is fine. I will note that should somebody disagree with that, as far as, you know, they say by limiting me to 1,000 square feet, that is a taking of my property, and there, you can't do that. And it ends up going to court. That is inevitably a factual inquiry that a federal court will make regardless of what we define it as. So to a certain extent, it comes down to, the Alice in Wonderland things. Words mean what we say they mean. And for this ordinance, we can say reasonable use means this. That doesn't necessarily affect how it gets reviewed should it later go to litigation. Does that make sense?
Yes, and I think because one of the things that we just recently started considering is whether we want to take that term out and just say, if you can't fit this amount, here's what you can do. So we're not even going near the term, and I'm just wondering if that's cleaner.
That may be cleaner, just not to confuse things, yeah.
Yeah, that's what I was wondering. Thanks.
Mickey, you've obviously read through the red line Ruth Walker sent in. Other than averaging, which I heard you and Keith having a chuckle on, what about the rest of them? What was your opinion on these changes? I guess where I'm going ultimately is someone who hasn't dove in as deeply as you and the rest of the people who spent an enormous amount of time, not over just since October, reviewing and considering this publicly and privately. What do you think changes that have been suggested by this professional? Across the board, take them? Do we move them forward to city council? What is your take on what you looked at?
My take would be that most of them, as Keith says, would be simple to just incorporate. It would make sense. To the extent that they're more substantive, yes, we should just pass it on to council for them to consider. But again, as Keith said, a lot of this does mirror what we've been hearing from the state anyway.
Okay.
So in other words, I would say there's something that can be incorporated plus passed on.
Other points people would like us to consider?
Just a clarification. So this draft that we have, and I appreciate you providing it, then is a draft that reflects DLCD comments and your response to DLCD. So it's up to date, except for comments that, my expert. So it is.
That is true,
Good.
yes.
Okay, thanks.
Say that one more time. Let's make sure that.
The DLCD comments have been incorporated into the draft that you're seeing.
This is where we start from here to change, if we change anything, and we talked about a couple things.
It might be helpful, just to summarize what happens publicly. If we say, okay, A, B, and C, we're going to move forward to city council.
Want me to? So what we'd be doing, so anytime we're talking about a zoning ordinance amendments, it will just kind of start from the beginning. There's a certain notice that we have to provide, the pop-up notice that goes to DLC notifying them that, hey, we're in the process of amending it. That's where we received comments. The initial action that's taken place with a zoning ordinance amendment is those amendments are heard with a initial evidentiary hearing before the plan commission, which we did in about October, had comments, created the new draft that's before you today, brought that back to you. You would now be making a recommendation to council if you so choose to do so. Then council, there would be another hearings process with notice and things like that to the public, notifying them that city council is considering the adoption of the wetlands amendments that they would have at that point in time.
Could I pause you just for
Yes.
1 second? We heard concern tonight that notice was not made
Yeah.
broadly enough, publicly enough. Can you outline for us how you're noticing?
Yeah, sure. So what we did on the initial evidentiary hearing was there was, I don't know if you remember, there was a Measure 56 notice that we sent out to, boy, how many property owners do you think? 400?
Those are between 400 and 500.
So we sent out about 400 specific property owner letters at that time to those properties that could be impacted by wetlands and the new buffer. So that was at the initial evidentiary hearing. After that hearing, that was continued, if you recall, to get to this point in time. Then what was required was we're required to have a 20-day notice for the hearing tonight, which is posted in City Hall, the post office, and then the post office downtown and the post office at the Surf Crest on Tolovana. So that's where we had to post it. And so there was no specific property notice letter that was required for the next hearing. But in addition, then we put out a press release on February 9th. We put it on the city's website. There's a mass mailing notice that the city has to get the information out to people. So with regards to all that, once we had the final draft of the ordinance that you have before you this evening, that's when all those additional notices were sent out about the hearing tonight. So there was the initial notice that was posted on January 31st. And that, again, that was the one at City Hall and the post offices. And then there was the press release and the notices on the website to put it out to the public.
Okay, thank you. Sorry to interrupt. I didn't mean to totally throw you off your train.
Yeah. So the next round, it will be, and I don't know, Bill, if you want to correct me if I'm wrong, but I think it'll be another evidentiary hearing before council.
Typically, I haven't dug into this in the code. It could be that council doesn't necessarily have to hold a evidentiary hearing.
Yeah.
Historically, I believe city council does hold evidentiary hearings, and so people would be able to come in and bring additional evidence or argument and, their concerns and support if they want to at the council. So you get it in the shape you want and you say, hey, city council, here's an ordinance that we think you should pass. And then the city council takes it and does what they will with it.
But were you asking a different question? I thought you were asking if we need one more in front of the planning commission.
I'm sorry, no, it would, at this point in time, we've had those, and if the plan commission obviously could continue this hearing, or if there was a favorable recommendation at that point in time, it would be forwarded to council. And at a minimum, we'd likely do the same type of notices in terms of the postings and the email blast and things like that.
And just be clear, if you were to continue it, you could continue it to another meeting where you have additional public input, or you could give direction to staff to make certain changes and bring it back just for further deliberations. You don't necessarily have to have an evidentiary hearing with public input.
How are you all feeling about what we have in front of us in terms of whether you feel like it's ready to move to city council, not liking it, or you want to continue?
I feel like, go ahead. Go ahead.
So I have a question, clarification, or maybe just a statement. I'm not sure which of the three it would be. But back to the beginning, one of the public comments was, or I think two of the public comments were about the inaccuracies on the GIS mapping on the city's website. And Aaron Matusik mentioned in one of the other public comments mentioned that any inaccuracies in the mapping would be a separate ordinance. I just wanted to clarify that that is the case. This is anything that changes here, we would have to then regardless, we would have to, either whether we pass this or not pass this, we would have to have additional hearings with the amendments to the inaccuracies on any mapping, regardless of what the decision of this level of enforcement is. That's correct, right?
Right, so this is not related to mapping. There is a requirement that if you are an applicant to build on a wetland lot of record and you have a new delineation, you have to provide your updated information to the city. So to that extent, this makes mapping better. It is better to have this code than what we have now if you're worried about mapping.
Mm-hmm.
What was brought up earlier was related to stormwater and runoff and not wetlands. It was not about wetland delineation. So that's a different mapping concern than anything that would relate to this code. So this code will only relate to wetlands, not to riparian areas or anything related to streams, etc. So we couldn't touch that today with this code anyway.
Okay, I was pretty sure that's what was going on. I just wanted to make sure that
It's confusing.
say it all out loud as much as to clarify it for ourselves and for anyone listening.
For everyone. I think it's very, very helpful.
Yeah, for sure. Okay.
And back up, because that's exactly right. The storm, I frankly think is an issue is I want to say her name is Merle, but I know it's not. My grandfather was named Merle. I have another female family member named Merle as well. So the wetland scientist was absolutely right to say what she did.
I think we got the intent of what you said there. Missed the first part, Aaron, but I think we got the intent.
Can I make a suggestion? I'm ready to go if the changes we've discussed tonight get incorporated, and I guess we just say motion to approve subject to the changes that Mickey requested and clarification of the chart at 1743-1.
That's a motion?
That's a motion.
Would anyone like to?
Second.
That's a second? Okay.
Yeah.
Before going to vote, would anyone like further discussion on this?
I have a tentative list of what I think the amendments are.
Why don't you tell us what you think?
Okay. One, we're going to go back to averaging as far as the terminology goes. It appears that we want to eliminate the reference to reasonable use that we have in, that's number 2. Correct table 1743-1 to include Planning Commission as the review body for those bottom uses. To get the terminology between the submittal requirements and the standards in 060 and 070 to be consistent. And just to take a look at that process again to make sure it's not confusing. And then on the buffer averaging for the up to 25% into the buffer area, if it's not possible to provide a buffer average on the property in question, then they would have to meet the mitigation requirements for the next one down. I'm not thinking of what we're calling it again. That would be up to 100% into the buffer, but not into the wetland, that you'd have to provide that mitigation. That would be number 5. And then number 6 would be to include Mirth Walker's comments And I think what I could do there, I could just go through her comments and indicate which ones got included and which ones maybe didn't, and give a reason why. But I think probably the vast majority we would want to include. So those are the 6. I don't know if there's something else missing, but I think that's what it was.
So I've got a question about making the modifications. Is it since this is a motion to recommend incorporating this to the city council, would it be better for us to see those final changes before recommending that, or does it not matter because we're recommending what's currently here with those 6 amendments?
We could do a tentative approval, look at them again, and then forward.
Yeah. What, Keith, how long do you think it would take you? Could you do that in say 2 weeks so we could
Oh, yeah.
do a brief,
Oh, yeah. Mm-hmm.
just like we do with the findings? Yeah.
That's what I was going to ask, like what we do with the findings. Okay.
Okay.
Yeah, really the hard part was getting to this draft and doing the reorganization and all the other stuff and trying to keep track of all the floating pieces. So this is more just change a word, insert this instead of that. And so that'll be fairly straightforward.
Do I need to remake the motion?
I think you could say plus that. What, Pete?
Was it seconded?
It was seconded.
Yeah, so
Good.
the option would be either.
Just go ahead.
I think we remake, don't we? If we had it seconded, don't we?
You've got to act on the motion, and to the extent you want to amend it any way you can, if there's.
Okay.
one or
So do you want to amend your motion based on what you just heard?
I don't think I need to amend it. Mickey, do you think I need to amend it?
Well, you would amend it to include what Keith said.
Well, okay, yeah.
So,
But we're not forwarding it to council yet.
so it comes back to the planning commission final review.
So it would be, we need to change it because it's a tentative approval, subject to the modifications that Keith just outlined for final review and recommendation.
On what's the date of the next planning commission meeting?
Well, and that's just it. That was going to be my question, because we were talking about dates, how we do findings and things like that. And I wanted to clarify through year. Do we necessarily have to, A, I don't have a calendar that we can go off of, but B, do we have to do any type of notice again as far as action or things of that nature?
So as long as, when you take action on a matter, as long as you continue it to date and time certain, you don't have to renotice. You're gonna have to renotice at the city council because you don't know when it'll go to the council. So if you give a date and time certain, then you wouldn't have to renotice.
So basically what we're talking about is we either find out a date we want to do that now, or we put it to next plan commission meeting.
We would love to get it done before we go on to the next planning commission meeting if we can.
Yeah, I agree.
All right, let's pull out our calendars. I don't know what the dates are that are, I suppose we don't necessarily have to have it at 6 o'clock either, right? We could just do, okay.
We do Zoom, you could do whenever.
Yeah,
For this room open.
okay.
Yeah.
Good. Keep that open for now. Thank you. Anyone want to toss any dates out to start with?
Well, I think the first thing I would want to know is when Keith comfortably could be finished.
Good
So
question.
that we're not pushing him.
You're muted, Keith.
I said it as comfortably, it would be June, but no, I can, this won't take very long. So I am out of town next week, but I can make a fair amount of progress tomorrow and then wrap it up. I'd say probably by where am I looking here? February. I can have it done by the 4th or 5th of March.
What if we looked at later in that week, either the 7th or the 8th?
The 7th is open.
Council is open on the 7th so far.
Let's take it.
Thank you.
Yeah, that works for me.
Take it.
Any particular time that you guys want? 11, 12, 1? Anything better?
I'm pretty flexible.
Yeah, I am too, Steve. Just put it up.
Anybody else? Any 11, 12, 1 o'clock? Any of those work better for people than others?
Later in the afternoon for me.
Yeah,
West
later for me as well.
And when you say later,
after
Just
1.
After 1 or 2 after 1's fine.
okay. And we are looking at Thursdays, so 1, 2.
How about we just say 2 o'clock?
2 o'clock on Thursday, March 7th. Keith, are you comfortable with that?
Yeah. I'll just
Tuesday,
promise
March
it'll be,
7th.
I'll just promise it'll be ready on the 5th at the latest, probably Monday.
So Tuesday, March 7th at 2 p.m. So Bill, do we need to specify that now any further?
No, that works, yes.
So then that we would just have the tentative approval and we're not really continuing anything, correct? We're just acting on the,
But when the review is gonna happen,
yeah. Okay.
All right, so we have a new first, an amended first.
and it's a friendly amendment, and if the seconder agrees with the amendment,
Thanks for getting this.
assuming everybody knows what it is.
Yeah.
Does the seconder agree with the amendments?
Yes, she does.
Marcy,
Okay. Any further discussion?
are you good with that?
It's the 5th, 7th.
So will you call the roll, please?
Do I need to be there?
Yes. Might not be bad if you could call in.
I can be there. Yeah.
Oh, Commissioner Ostrander,
Yes.
Commissioner Matusik,
Yes.
Commissioner Bates.
Yes.
Commissioner Moritz,
Yes.
Commissioner Sinclair,
Yes.
Chair Newton.
Yes. The legislated suggestion is tentatively approved.
I want to congratulate Lisa and Mickey on that final art. Great work. To both of you, Mickey, Lisa, thank you.
Well, thank you to you too, and thanks to Herbs Works.
And Mickey and Marcy, for sure. And Keith. And who's the, and you two, and who's the gentleman that, gosh, once you get, now I know where the Oscars
keep
get
going,
out of
buddy.
control. Who's the gentleman that helped? Ethan, yes, thank you.
A wetlands biologist.
Yes.
Let's see, I have on here the tree report. I might be blindsiding you with that, Robert. Do you want to talk about that?
We only had a couple of removals early January. Let me bring that up here. So one of the properties listed here, the 143 Tanana, that was a Public Works right-of-way tree. The other two, the one at Cannon Beach Hotel at 1116 South Hemlock and 763 Ocean Avenue. Those were both hazard trees. And of the 4 trees that were removed, all 4 of those are required to be replanted.
Anyone have any questions on that? Okay, let's move to good of the order. Anyone have anything for the good of the order? Online, and you guys? Okay, well, with that, we'll adjourn. Thank you, everyone.
Thank you.